The book discusses tax disputes between states, and tax disputes between states are always fought on the back of a taxpayer. Somebody has to pay the tax, and the litigation goes on in two states, but what we see is that if you fight these litigations in domestic courts, you have answers by one court which are not necessarily consistent with other courts. So we need international fora to do that, and we have been discussing that during the conference, and the documentation prepared by the conference is laid down in books. Things have developed over time. We have the minimum taxation of multinational companies, we have the taxation in the market jurisdiction, all draft new rules which complicate the matter significantly, and we have been discussing, and the book discusses how the existing instruments can achieve the goal of avoiding double taxation, and if they do not, how these instruments can be improved. It is a very difficult subject because it deals with domestic law, it deals with international law, with treaty law, and also with European law. And at the same time, the book discusses how the rights of taxpayers can be protected, how that protection can be enhanced.
My contribution in this conference and in this book is about the person covered by the mutual agreement procedure, Article 25.1 of the OECD model, and I particularly address the point about transfer pricing cases, and also about how you can handle this situation. Who is the person covered when you have a permanent establishment? Can a permanent establishment request the MAP? To which authority, to which competent authority must the taxpayer, the permanent establishment, send its claim? That's what it is about.
As you can see, my presentation dealt with the phrase will result or will result in taxation not in accordance with the convention. So I've basically addressed both issues, the meaning of result or will result, and then I spent more time on something that is a bit more interesting. What is the meaning of taxation not in accordance with the provisions of the convention? And there I made it very clear that the treaty does not require, unlike the EU Arbitration Convention, that there be double taxation. It simply says the moment you have taxation which you consider is not in accordance with the provisions of the convention, then you can initiate the MAP. And in that regard, it's very interesting, and that's something I also discuss, that in transfer pricing cases, what is really not in accordance with the provision of the convention? And I make a distinction between the initial transfer pricing adjustment and the corresponding adjustment. My conclusion is basically, yes, a corresponding adjustment or failure to do so is taxation not in accordance with the provisions of the convention, whereas if you look at paragraph 1 of Article 9, if you have an adjustment to the profits which is not in accordance with the arm's length principle, it's a bit more difficult to argue that itself this is taxation not in accordance with the provisions of the convention.
The topic I had to deal with in this conference and book is acceptance and denial of MAP requests and related remedies. Mutual agreement procedures are very specific procedures, intergovernmental procedures, where tax authorities have discretion to admit or reject the specific request of the taxpayer. The OECD has been trying to limit that discretion over the years. That has been the OECD's strategy, but somehow what public consultations and the opinion of stakeholders is playing is that they still have problems of access to mutual agreement procedures. So the whole chapter and my presentation was about potential remedies, about these arbitrary denials of mutual agreement procedures, how effective these remedies could be, and other solutions and proposals that I put forward in order to reduce the discretion that competent authorities could have, and also how these specific MAP procedures can connect with arbitration procedures that in the end are the final phase of mutual agreements.
I talked here today about the possible outcomes of an admissible MAP case. In fact, we looked at all the possible outcomes that there are according to the OECD MAP statistics. There's some 10, and except for access denied, which was dealt with by another presentator, I talked about the 9 possible outcomes and explained when they can happen, so within the unilateral phase, the bilateral phase, or in between or during both phases. And in the end, I also discussed a little bit which are good outcomes, which are bad outcomes, which outcomes are sometimes good, sometimes bad, and which outcomes are completely neutral. Thank you.
Our contribution, myself and Jacques Sarsfield, will cover the domestic procedure and MAP, and particularly we will address the interaction between court litigation, which certain countries require to be initiated in order to have access to mutual agreement procedure. We will also address issues which do arise in the parallel between MAP and domestic litigation, such as penalties, which falls within the competence of domestic courts, and MAP, which is relevant for the purposes of the determination of a tax adjustment. We will also address issues regarding suspension of court proceedings in the context of MAP, and also application of suspension of collection, and also refer to tax treaties which include the penalties and suspension of a collection within the MAP process. Our paper covers dispute resolution under the global rules in the context of Pillar 2, taking into account that Pillar 2 model rules do not provide for any dispute resolution mechanism. They provide a tool for domestic provisions. No treaty is considered to be concluded, and therefore dispute resolution remains as a domestic law issue and requires solutions. We are proposing 3 solutions. The first one is an enhanced interpretation of Article 25.3 of the OECD Model Convention. We also consider a domestic provision to be included in the model rules, which on a reciprocity basis provides for dispute resolution mechanism. And also we consider the use of the mutual assistance tool in order to complement the domestic provision on dispute resolution. Finally, we consider a general rule of interpretation of the domestic rules reflecting the global rules in the context of the work of inclusive framework.
My contribution regards judicial control of the MAP process. I try to distinguish various situations in which a tax court has to address issues related to MAP, like the fact that a MAP would be allegedly illegal, or that a MAP agreement has been reached and not implemented, and also address other types of issues, like the intervention of the court as a judicial review judge, regarding especially a denial of a MAP procedure that might be illegal, and also the possibility of court control over later stages of MAP, like the decision to stop a MAP without any agreement being reached.
The title of my contribution is A Judicial Experience with Mutual Agreement Procedures. In my contribution, I discuss the Dutch experience with the interaction between MAPs and domestic legal proceedings. I focus especially on the judicial control of the MAP procedure from a Dutch perspective. And then finally, I give some personal experiences and observations as a judge from MAP cases.
Yeah, I'm very happy that I can attend Professor Maisto's conference again. It's a very traditional conference, and Professor Maisto has done a great job over many years to organize very important conferences in the area of tax treaty law and well-prepared conferences on hot topics. So in the past I already had the pleasure and the privilege to participate in several of these conferences and also to contribute to the book, and I always learned a lot, and this is true this time as well. I think the topic dispute resolution, mutual agreements, arbitration, I think is not only from an academic point of view a very interesting topic, but also from a practical point of view a very relevant topic. And what I've learned through the discussions already, that there are so many open questions in that area. In particular, tax treaty law and domestic law is very closely linked. Courts, tax administrations play a very important role, and also the rules have been there for decades, almost ages. It's surprising how many interpretation issues are still not resolved by courts. And of course, there are also very recent developments which are also covered during the conference and which will be covered in the book as well. Arbitration plays a more important role. Of course, there are more disputes, so therefore it's more important that we have arbitration clauses and that the European Union implements rules. That's extremely important for tax practice, and therefore also new legal issues come up, and we are hearing a lot of possible solutions, interpretations, which are discussed again on a very high level here in Milan, and which will be presented and further developed in the book which comes out.
My topic and my contribution to the book is on Article 25, Paragraph 3 of the OECD model, which gives competent authorities room to solve difficulties or doubts which come up when applying or interpreting the treaty. There is a lot of confusion on the exact scope of this provision, and more in particularly, which also will be dealt in with the book, on how to explain doubt or difficulties and how to determine what the mandate of the competent authorities is to enter into such a mutual agreement. So they are not allowed to modify the treaty in a substantive way. They really should stay within the limits of solving doubts or difficulties with respect to interpretation or application of the treaty. There is not a lot of case law on this, so we really are stuck with the commentary on the OECD model, which is not always clear, but there is some commentary on this mutual agreement, which I also will deal with in the contribution to my book. And a second type of mutual agreements which I'll deal with are legislative mutual agreement procedures, which are in fact which give the competent authorities the room to fill gaps in the treaty when there comes up a situation of double taxation, which mainly focuses on situations not coming on the personal scope, on the subjective scope of the mutual agreement procedure.
The topic that I will address is the change in 2017 to Article 3.2 of the OECD model that concerns competent authority agreements that affects the interpretation of an undefined term used in a model-based tax treaty. In this contribution, I will trace the history of this amendment to the OECD model, in particular its history in US tax treaty practice, and furthermore I will contrast it with case law from Europe mainly, that is found this type of agreement about treaty meanings problematic. And then I will conclude by making some suggestions about how this matter should be resolved. The position in the model is not satisfactory, it's incomplete. Guidance is required about transparency around competent authority agreements and their publication. And hopefully all of this will make a contribution to more effective resolution of disputes in a cross-border context.
My contribution highlights the differences between the various dispute resolution mechanisms, including and focusing on different deadlines, procedures, and relation to domestic remedies, as well as the implications of European Union law, highlighting especially the impact of EU fundamental rights and the requirement of uniform application of EU law.
The dispute resolution under the Tax Treaties and Beyond is a fascinating topic, and the book itself presents the chapters from the reporters from different jurisdictions. And I gave a more of a EU perspective, so a more broader perspective of how in general the member states have dealt with the transposing of the directive in the EU and the trends we observed there. So at this point, all the transpositions have been completed, and now we are also in the process of checking the correctness. In addition, we are also dealing with a project on the Standing Committee, and that is implementation of Article 10. It's an alternative dispute resolution commission, and it should be more tangible in the next year. Then another interesting element to the dispute resolution under the tax treaties that arises is in the context of the international tax reform. So at the OECD level, the Pillar 1 and Pillar 2 are being developed, both on the substantive law aspects and also on the procedural law aspects. And once also the elements of dispute resolution under those two pillars become stable, we need to see how they translate into the EU legal framework. And then the interaction with the dispute resolution directive should be, of course, accounted for. And also it would be interesting to see in the following years how practically the disputes that MNEs will face will arise and how they will be resolved under the current instruments and also under the instruments that are still to come.
Dispute resolution in tax matters has never been so important as today. It will be even more important with the advent of reforms in the international tax architecture. This book brings together contributions based on a seminar in Milan solely on dispute resolution, and it brings together very fine contributions of top experts from government, academia, private practice, who have gathered here for a day and a half to study very precisely the mechanism and interpretation of dispute resolution provisions and the interaction of tax treaties and domestic dispute resolution mechanism. And this is all now together in this book. It is a must-read for those active in international taxation and dispute resolution.
My contribution focuses on the role of taxpayers in cross-border tax disputes. Certainly, cross-border tax disputes are disputes between states. However, the developments in public international law and international law in general show that taxpayers, just like any other private actor of international law, are not just objects of disputes between states, but also holders of actual rights. From this perspective, the research focuses on whether taxpayers might have legal standing in respect of the interpretation and application of tax treaties, taking into account the interpretation in good faith. And this actually relates to the rule of law and the effective protection of the rights of taxpayers.
My contribution will relate to the relation between dispute resolution under tax treaties and investment treaty arbitration. I will be exploring selected consideration. I will first be looking at how investment treaty arbitration has evolved in terms of giving investor a direct right to initiate investment treaty arbitration. And I will be contrasting this with, on the other hand, dispute resolution under tax treaties, which remains rooted in diplomatic protection, and whether that justification or that route in diplomatic protection remains justified. Next, I will also show how the investment treaty arbitration practice can also influence the interpretation of access to the mutual agreement procedure under double taxation treaties. And I will also discuss the interaction between dispute settlement mechanism under tax treaties and dispute settlement under investment arbitration, and I shall demonstrate that they operate in parallel, they may operate in parallel and govern different subject matters.